This pre-trial review is in the matter of CFI 013-2019 before Justice Sir Jeremy Cooke and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by King and Spalding. Lead counsel is Tom Sprange QC. The defendants are represented by Gibson, Dunn and Crutcher LLP. Lead counsel is Tom Montague Smith QC.
Yes, very good. Are you going to introduce the matter, Mr. Sprange?
Well, if you like. You mean formally in terms of the parties, or
No.
No.
I
Oh,
don't
good.
think we need trouble with any of that. Thank you.
No.
Sufficient, unless you wish to introduce any of your team or anything.
No. I'm on the call with my colleagues Sarah Walker, Ben Williams, Katra Vlova, Jawad Ali, and Alicia Stakakis. Those are the introductions I need to make. Oh, along with Lisa Wong, our chief paralegal.
Okay, thank you very much. You have your a team with you, presumably, Mr. Montague Smith, do you?
I do. I've got Mr. Lovett and Mr. Stewart from Gibson Dunn. Thank you.
Very good. All right. So far as the previous directions are concerned, I take it from the pre-trial checklist that everything's been done that ought to have been done. You nod happily, so yes. That's the case.
Yes, I think I think there may be a few things that have been done slightly differently from what was planned, but I would say there's material compliance with all of the previous orders.
That immediately raises suspicions, but material plans. Yes, all right.
I don't know about anybody else, but I'm having trouble hearing or seeing the judge, who seems to be frozen.
Yeah, same for me.
Really, it's just, well, I suspect I know why that is. It's 9 o'clock here, and I think everybody in this block of flats turns their computer on at 9 o'clock in the morning, or so it would appear. And so the bandwidth suddenly gets eroded a bit, but it'll probably come right in a few minutes. Are we all right for the moment?
Yes, you froze for about 20 seconds, but it seems to be fine now.
Okay. I think essentially what we're doing is just looking at the practicalities, unless there are particular matters that you need to bring to my attention.
No, and it struck us that probably the most important was one of the last items on the agenda, which is skeleton length. And although we have our views, we thought your view was probably the most important.
Did you have the agreed agenda? There's a sort of.
I've got the agenda.
I'm grateful.
Yes, that arrived this morning. Yes, I've got that. Thank you.
I wondered whether it's worth just bouncing through those points very quickly.
Well, let's do that. And I'm working on the basis that you're saying 10 to 12 days is required, and I would like to see a timetable in relation to how that works out.
You'll find that timetable at page 107 of the bundle. This is our current estimate of where things are going.
Oh, right. Okay, thank you. I missed that.
And it's tab 9 if you're after tab numbers.
Thank you. Oh, yes.
So in broad terms, I think the parties agree that we're likely to get to the end of the lay witnesses by day 7 or thereabouts as an estimate, and then we're on to experts and closings. And I think the slight difference between the parties is how much time we spend on experts and how much time we spend on closings, and whether we have some sort of break before closings.
Yes. I haven't explored the expert evidence at all, I think. So essentially, this is valuation lost profits, is it?
Yes.
You
Well,
can
I
get a
can-
feel for the issues on the expert evidence if you were to look at. There's a joint statement actually in the bundle. So we included the evidence in the bundle just so you can get a feel for what's going on there. So it's tab 23 is the joint statement. I wasn't planning to take you through it in any detail.
Oh, okay. Well, I'll have a look at that. But I mean, the reality is that I mean, it's a sufficiently indicative timetable not to worry unduly, isn't it? And we can cross the necessary bridge when we get there and see how things are actually going in practice.
Yes, and I don't think certainly from our perspective, if Mr. Montague-Smith wants to spend longer with experts than we do, but we want to spend longer on closing than he does, or vice versa, I don't think that really matters. It seems to us that we do have. I won't use the word plenty because that can make us a hostage to fortune, but we certainly seem to have enough time. As long as there's broader quality, I think it really should be up to the parties how they want to spend it with a lazy eye on this timetable.
I'm much less interested in equality of time sharing as to fairness in the overall sense.
Yes,
you know,
yeah.
what's required. You know, the concentration on equality of time in arbitration, I think, isn't usually misplaced because parties have different cases to pursue and therefore different requirements as to what's necessary to pursue them properly. Anyway, as I say, I don't think that's a problem. We could probably take that as it comes. I'm broadly speaking, if time permits, then I'm happy to have a gap before you give closings. But what I'm not having is post-hearing briefs or anything similar. It's got to be closing speeches and so on. And I mean, I've read the pleadings again, so that I'm familiar with that, but I hadn't really had much opportunity to do much else prior to this pre-trial review. Okay, so I think we can leave the timetable issues for the moment on the basis that you're both being cooperative, and we'll see where we get to.
Thank you.
All right, thank you. That's helpful. Now, so far as the sort of basics are concerned, we're now beginning on Monday, the 7th of February, and sitting Mondays to Fridays. That appears to be the new norm in Dubai, which is helpful from most European perspectives. I see you want to sit 12 to 6. What's that?
So we're certainly from the claimant's perspective, we're flexible. I think if we had a preference, it would be 1 to 7 Dubai time, so 9 till 3 London time. But a little like the timetable itself, we would be happy with an approach that said the default rule is 1 till 7, 9 till 3 London time, but we could change that if it's necessary during the course of the hearing.
Well, I think a little bit depends on. This isn't simply for the convenience of counsel or the judge, who would prefer a 9 o'clock start, undoubtedly to an 8 o'clock in the morning. But the parties themselves are situated where, in fact, I mean, the key people from your side of the fence, Mr. Strange, where do they actually situate?
A combination of here and the Middle East. So we've got people in both time zones.
Right, but it doesn't go further east than the Middle East.
No.
Right. Okay. And asking the court staff, Maita, is there a problem about timing at all from the court staff perspective?
No, Judge, it should be fine, but Usually we do list trials from 12 p.m. until 6 p.m. But if you're comfortable, then we can, like we do not mind to list it from 1 p.m. till 7 p.m. It should be fine.
Okay. Well, I assume you've taken your client's instructions on the point, so that if the parties are happier with 1 till 7, I'm very happy to go with that from my perspective. Makes life slightly easier for me.
We're pretty agnostic as to that. All of ours are in Dubai, but I'm told that there's no problem from our end of people sitting till 7, and I think probably the considerations of the registry are the most important in this regard, because they're the ones who are making work into the night. But it sounds like that's not a problem.
Yes, I mean, in reality, and without wishing to be hard line about it, it just means a slightly later dinner for them. Well, let's start off by sitting 1 till 7. We'll work on that basis, and see how that appears to work out over the first few days, and we can always adjust as necessary, depending on witnesses and so on and so forth. Okay, so that solves that problem. That's item 1. Real-time transcriptions. Where's the issue here?
Well, it's this simple. We would like it. We think it's worth the extra investment, particularly in a case of this value. So it's just a debate about who'll pay the extra cost. We would like it to be 50-50, but we're so keen on real-time transcription. If there's not equilibrium on that, we'll pay for it and we can sort it out later.
Yeah,
well, I think all come out and the costs awarded at the end of the day. But do I understand from that the defendants are not thinking that real-time transcription is a good idea?
It's not that it's not a good idea. I think our position was that it's not completely necessary. If the claimant wanted it, then they ought to pay for it. So the difficulty we're faced with is that we are well past the amount of security that's been ordered. So we're now into the zone where we're just completely unsecured for additional costs that come through. The defendants don't have, the claimant doesn't have that problem, because obviously we're in the defendants are the DIFC and are in the DIFC, and it's easy to enforce, but it may be more difficult the other way around. So we would hope that the general rule would apply, which is just that the claimant pays for the trial, for the preparation for the trial, and that, as you say, comes out in the wash in the cost order at the end.
I'll go with that, Mr. Strange. You pay up front, I'm afraid.
That's fine. As long as we have real-time transcription, we're happy.
Very good. All right.
I think we've dealt with C3 and 4 already.
Yes, on the basis we're just putting it off, essentially. Yeah.
Yeah.
Now, how long skeleton arguments do you think you wish to put in?
Well, if Mr. Montague-Smith nods, I'll keep going about the informal discussion he and I had the other day. Limit is 25. I was on 35. He was on 50. So we're somewhere between 35 and 50. And again, I'm pretty relaxed. If it's 50, if you're happy with 50, then certainly we are. But we both agree it should be more than 25.
Yeah, I mean, from our perspective, I think it will be more than 25. There is a fair bit to unpack here. There's a fair, and particularly if we're not going to have any kind of written closings, you might want a fairly, not extensive, but comprehensive base for your judgment. I'd hope that we would be 40 or less, but I mean, we suggested 50 because it may be that much based on past experience from the sort of trials of this sort of length and this kind of level of documentation. I hope that we can be trusted not to bog you down with unnecessary words. I'm not going to write 50 pages just because I've got 50 permission to do so. So it may well be shorter than that, but I wouldn't want to have to come back to you and say, well, you've limited me to 50 to 35, and actually I need a few more. That's the only thinking there.
How much law is there in this case?
A bit. There's a little
yeah,
bit.
Yeah, I don't think
We've
it's
got
a great deal.
Sorry. There's a
Go
little
on.
bit. There's a bit.
Mr. Strange.
Sorry.
There are 2 or 3 issues of law that I think we will need to spend some time on, but they are familiar to you. And for my part, I certainly won't be bombarding you with 24 authorities about the principles of each of those issues. I can say this for our skeleton. I can say that for our skeleton, there may be some attachments in terms of tables in relation to damages and things like that. So we certainly won't be too wordy, and we will be light on the authorities as we can.
Well, just let's have a quick run through and see what issues of law arise. Obviously, one's looking at questions of renunciation, affirmation, and so on. But I mean, those are essentially going to turn on questions of fact, aren't they, rather than anything else? There's not likely to be much dispute about the principle.
No, I think there will be some DIFC law issues that we do need to make sure we're familiar with. For me, I think that
that goes to the sort of nature of the breach point.
Exactly, nature and timing of breach. There will also be some issues on the law with respect to damages, causation and appropriate measure of damages. Those I think are the more, they're not particularly complicated, but they will require some attention.
Yes.
Yeah, I mean, the one interjection I would make, if I may, is simply this, that obviously we're dealing with DIFC law. DIFC law of contract is not English law of contract. It's quite different. It's the unitoire principles. Your Honour's dealt with them in many cases previously, but 1 or 2 of the differences may come to bear on this particular case. That's all. There's going to be a few issues about whether or not the duties under the contracts were, quotes, continuing. That may well be a live issue. There's a little bit of law on that, and that goes to the question of limitation. And on limitation, there's going to be a little bit of law, I suspect, about how the law of limitation, questions of continuing breaches, interact with questions of renunciation. So, in other words, what are you renouncing? You're renouncing future performance, and how does it interact? It's not going to be hugely extensive, I don't think. But there's just a little bit that needs to be unpacked. There are some differences on the meaning of contracts, the meaning of documents between us. In particular, the 2008 shareholders agreement is a prime example of that. And there's going to be a little bit of investigation, and I don't think it's necessarily going to be too extensive in the openings of the nature of the parties' interactions, particularly between sort of 2010 and 2018. Were they effectively trying to pursue the JVA? Were they trying to do something different? So it may be necessary just to bring your attention to a few of the documents as we go through that. I mean, I'm working on a few submissions at the moment. I genuinely think, without too much fat, I will end up around 40. Whether I need 50, I don't know. But there we are.
To be frank, I don't have a problem with 50 pages. This is a 3-week case, and it's helpful often to have parties' arguments spelt out from the outset. And the pleadings are fairly full, and the pleadings, in many cases, descend to quotations or at least references to exchanges between the parties over a period of time. There is an extensive period of time, of course, but there we are. Yes, all right. 50 pages you can have, and I don't need to say to you, don't be unnecessarily verbose. All right. Virtual trial protocol. What do you mean by that?
I think that was a topic rather than anything in particular, and related. As far as I'm aware, the only really contentious issue that's been raised in correspondence between the parties is just how we intend to have witnesses placed and who will be present in the room when they're giving their evidence. And again, because of the level of cooperation that we've happily had so far, I don't foresee any further controversy on that. And I also think that the typical questions that the presiding judge or arbitrator asks these days ought to cover off those issues. So, you know, you're alone in the room, you've only got these documents, you won't receive any assistance, etc. So from my perspective, that rather generic item in the agenda, item E, it really comes down to the practical question of witnesses in terms of differences between the parties.
Right. This trial is going to be completely virtual, is that right? So there's going to be no one in court other than the video camera and the associate, so to speak.
Yes.
Which means that everybody will be operating either from offices of the lawyers concerned, or perhaps witnesses or experts even from home. Is that right?
That's right. Yes.
Yes.
And if you may not want us to descend into this detail, but certainly from the claimant's perspective, we are yet to decide where we will gather. But it's likely that there will at least be some people in London and some in Dubai, where our witnesses are. So some of our witnesses may be giving evidence from King and Spalding's offices, either in London or in Dubai.
Yes. Well, I think obviously I would like to know what the position is with regard to who's congregated where when the trial begins, and from where, therefore, various witnesses will be giving evidence, so that I have some handle on that.
Understood. And we can perhaps add it to the indicative timetable, because in there we're naming witnesses, so we can put where their location is.
Yes.
Yeah.
And an administration of oath and so on.
Excuse the pun, fairly agnostic about that, whether it's a declaration or oath. I think particular witnesses will have their own requirements, but I think if we make available to you the 2 or 3 options that will cover all of the witnesses.
Well, I'm thinking of the practicalities also, because if a holy book is required,
yes,
the person needs to have it to hand. And in a number of arbitrations of late, and indeed court proceedings where it's more common to have a formal oath, we've discovered that people who wish to give the oath didn't have an appropriate Bible or Quran anywhere to hand, which
yes,
may have lessened the force of their oath.
We've had
take it sufficiently seriously to have the relevant holy book anywhere in their house.
Yeah, we've had a similar problem. Well, probably about a year ago. So now all of our officers are duly equipped with all relevant relevant requirements. And so my humble suggestion is we make it the responsibility of the parties. If you've got a witness who needs a Quran, you make sure one's available, or a Bible, or if it's just an affirmation, then yeah. So as long as we make it our own responsibility, and then you'll be in a position to administer whatever is required.
Yes. All right. Okay. Now that's essentially gone through your agenda. According to the directions order of the long ago as the 1st of March 2021, trial bundles, reading list, skeleton arguments, chronology, dramatis personae. Can I take it all those things are, if not finalized, at least in hand, and no problem?
Yes is the answer, with emphasis on the if not finalized, in hand.
Right. Okay. And reading time for me?
I know you're a quick study, my lord, but I do think it's probably 2.5 days.
I think that sounds about right.
I mean, looking at the pleadings, it appears to me that realistically, I need to have done quite a lot of reading of the exchanges between the parties in order to see the context in which the witnesses are going to be giving evidence. Personally, I like to have a handle on everything before witnesses give evidence, because otherwise, if you're looking at documents for the first time whilst witnesses are being cross-examined, you're not really following the points as well as you should. So
Yes.
if there's any adjustment to that, is to you think it needs more than that, please send an email to the court to say so.
If it's any help, that the trial bundles are largely there, insofar as, even for the purposes of this hearing, we have a master bundle. So bundle F from that is the contemporaneous communications between the parties, and that's 355 documents. It's obviously a lot more pages. So it is quite a lot, but I tend to agree with your observation. I do think this is one of those cases where the contemporaneous communications between the parties is pretty important. And for me, just in terms of my view, my worldview, the pleadings are important and the statements are important, but in some ways that's the most critical, because there's a lot of emails between the parties that reveal a great deal of their real views, we'll put it that way.
Well, and the reality is, if you're looking at a history of matters going back the better part of 20 years, the idea the witness is going to have any real recall, apart from looking at documents, is, pretty unreal. I mean, they will have a very broad recollection of things, but no details as to what really took place over a period of time that aren't going to be in the documents. All right.
Your Honour, it sounds to me like what you're asking for is a slightly more extensive reading list than might otherwise be the case. And perhaps what we can do is try to ensure that you have a sort of traditional reading list which directs you to the central core documents, contracts and all the rest, but then perhaps a separate list of key communications that the parties particularly would say it might be worth you having a look at in advance, just so that you're not faced with a sort of 3,000 page bundle and trying to find your way through that. But at the same time, you're not confined to just the contractual documents.
Yes. Is there an index for the trial bundles that's already been agreed and so on and so forth?
Yes.
Have I seen that, or has it been made available to me?
It'll be on case lines.
Yeah, and we could probably send you a PDF, but there's also a core bundle, but I would certainly say that that's a little light at this stage.
All right. Well, I would welcome I would welcome a reading list that was more rather than less.
Understood.
Thank you. I personally want hard copy documents. I know there's going to be an electronic bundle and so on and so forth. But certainly, so far as the key stuff is concerned, I infinitely prefer hard copy because of making notes and so on and so forth. And simply being rather old-fashioned, I find my way around hard copy bundles quicker than I do the electronic stuff, to be frank. So I'm not quite sure how that's going to work, but they'll need to be delivered to me in my London flat.
So Ms. Wong's on the line, and she sent me some instructions, as is often the case. She said, could you ask his lordship whether he would like A4 or A5, single-sided or double-sided, binders or spiral bind?
I'd like A4 double-sided, and I'm fairly relaxed about the file format, so to speak. But if the bundles, if there's not going to be lots of late insertions, well, it's really whatever's easiest. They stack better if they're in lever arch files rather than the spiral bound. But I'm not terribly fussed. I'm not you know, if they're doing a whole lot for everybody and so on, then I'll go with the flow on that.
Fine. No, I think typically the pleadings are spiral bound, and then everything else is binders.
Fine, that sounds very sensible. Thank you.
But it's A4 double-sided, right? Not
A4 double-sided.
Yeah, fine. And on the basis that all it will be used for is for Ms. Wong to send you the documents. Perhaps you could email you offline, copying Mr. Montague-Smith and I, just to get your address so they end up at the right place.
Yes. There's a slight issue, as you may know. I have multiple email addresses because the court insists that I have a DIFC one. The Singapore court insists that I should have a Singapore one. And so it goes on. I hate to tell you how many I've got, but the reality is I don't like to look at 5 different email accounts every day. So if I can simply give you the one that I use primarily, which is jcooke@7kbw.co.uk, that will be the easiest one and the one that I shall look at first every day in any event. If the DIFC court has a problem with that, then you'll have to send it to the DIFC court address, the one which I can't remember the exact details of, but the court can give you. So I don't mind you using that at all, as long as everybody's copied in.
Yes, fine. We'll still communicate with you about the bundles and delivery of them at that address, and copy. Tom, do you want anyone else from your side on those mails? You're on mute.
No, that's fine. If it's just about the destination, that's fine. Thank you.
Okay.
All right. Is there anything else then that we need to cover?
Not from the claimant's perspective. If I could just check the group chat to make sure I haven't missed anything.
Yes.
Nothing more. We're content. Thank you very much for your time.
Sorry, I'm just looking at my notes. Yes, anything from you, Mr. Montague-Smith?
Nothing from me, Your Honour. Thank you.
All right. Well, if anything untoward turns up, or you need any further guidance before we get to the relevant dates, then approach the court and something can be arranged.
Thank you.
Thank you very much.
Okay, there we are. Good enough. Thank you very much, everybody, and see you in due course.
See you in due course.
Thank you. See everyone.
If you,
See you, Tom.